Hello, I'm Ken Swinton. I'm a council member of the Scottish Law Agents Society, and this is one of our free CPD offerings for our members. So the title today is Liability for Home Reports. What I intend to do is speak first of all about liability of surveyors for negligent surveys at common law. Then I'll look at the liability of surveyors under home reports, and then I'll say something about liability of the sellers for home reports, which will fall in the property questionnaire part of the home report itself. I'll also speak briefly about liability of sellers for misrepresentation at common law, out with the scope of home reports, perhaps, and also liability for sellers under missives. But in relation to those topics, I will really signpost other resources that cover them in more detail. So before I do any of that, I'm going to speak a little bit about the background of how home reports came to be. There was, for many years, a dissatisfaction with the existing system from prospective purchasers, particularly first-time purchasers, where they were obliged to instruct their own survey, and they regarded that expenditure as wasted where they were unsuccessful at a closing date. The question about how unsuccessful they were and whether the report was in fact wasted is something of a moot point because they're paying for information and they received the information on which to make a decision as to what to offer. So in that sense, it wasn't wasted, but it was perceived as wasted and was seen as a barrier to first-time purchasers. And therefore, there was a political will to do something about it. This was also happening south of the border, and it seems to be that the development south of the border, which came to naught, in fact, influenced the establishment of the Housing Improvement Task Force by the Scottish Government, then Scottish Executive. That task force recommended fundamental change to the buying and selling process. And their recommendation was that the seller should commission and pay for a survey, a single survey, which was made freely available to any prospective purchaser. The task force also commented that prospective purchasers, or purchasers perhaps, were concerned about lack of timely information, which slowed down the conveyancing process. Now, the conveyancing process is really quite straightforward. You get the land certificate or seisin titles, you instruct searches, you obtain a property inquiry certificate, and there are no delays in any part of that process. However, the task force seemed to think that these things represented brakes on the speed of processing. My experience in practice was that the brake on transactions was always with the lender. So it came to be that included in the home report was the property questionnaire. Much of the information there is only required at settlement, such as who the suppliers are for energy, broadband, and the like. So whether it meets any specific need is a moot point. And I doubt whether the existence of the property questionnaire has much impact on purchasers or in fact on the conveyancing process, unless of course the sellers start telling stories in the property questionnaire, which can become somewhat confusing. After a pilot to see if the system could be changed voluntarily, it became clear that that was not the case, and it was necessary to legislate for this. So provisions were included in the Housing Scotland Act 2006, section 99 onwards, and these focus on what the Home Report will look like. The sections it will contain are contained in secondary legislation, as we'll see in a minute or two, and the availability of the Home Report to prospective purchasers free of cost was the main focus of the primary legislation. Now, one might expect the primary legislation to deal with the actionability of the contents of home reports, but it doesn't. At one level, it might have been thought that that was simply an oversight, and it was always assumed that the surveyor would be liable to third parties for the content of the home report. The principal legislation is also silent on the standard of care and to whom that duty of care is owed. And there are two statutory instruments. One, a Scottish statutory instrument, the Prescribed Documents Regulations, which gives the form of the home report as we see it today, or not quite, and I'll come back to that shortly. And the second is the Consequential Provisions Order, which is actually a Westminster statutory instrument. So while the first deals with the form of the home report, the second deals with liability, and the explanatory memorandum to that statutory instrument makes clear that it is a matter of consumer protection. Consumer protection is reserved to the Westminster Parliament, and hence to make the scheme work at all, it was necessary for the Westminster Parliament to intervene. So that gives a background to the structure of this. If we look at the prescribed documents regulations, the home report is to comprise three sections. And those three sections are the single survey, the energy performance certificate, which is usually prepared by the surveyors, but need not be. The surveyors have to be trained to become accepted as providers of energy performance certificates. And of course, the energy performance standards have changed once since home reports were introduced. And at the time of recording this in March 26, further changes to the EPC will come into force. But if you look at the regulations carefully, there's no reference to the mortgage valuation, which is contained within the home report typically. Now, obviously from a lender's perspective, if they are going to rely on the home report, they want something as close as possible to what they were used to, and it has become the practice, the established practice, for a mortgage valuation report to be included without statutory authority in the home report. Not every lender will, of course, accept the home report mortgage valuation. They may instruct their own survey, or they may require transcription of the generic mortgage valuation into their own format, in which case it's easy to see that there's a direct contract between the surveyor and the lender. But where they don't and rely on the generic home report mortgage valuation, presumably they rely on the normal law of negligence. Now, that's interesting because it's not a statutory form, so it must be a common law liability. The Westminster Order contains in Article 3 the provisions whereby a buyer has a potential claim against a surveyor. And those conditions are that they have obtained a copy of the survey report, they have suffered material loss, and I'll deal with material loss shortly, So if those two conditions are satisfied, then the buyer has a claim. Okay, so what's required? The survey must be based on an inspection. It must have been prepared in a way that is fair and unbiased, and it must have been prepared with reasonable skill and care. The fair and unbiased means it's fair to the sellers and fair to the purchasers, and we understand that from the inability of the sellers to influence the content of the home report survey. So for the purposes here, material loss is stated as the market value of the house on the date, and that being lower than the value given in the survey. So it has to be materially lower. That's the important thing. And the buyer must have paid more than the actual worth of the property. So we can describe that as value with the defect and value without the defect as prepared by the surveyor. So I'll refer to this as we go through as a plus and minus defect test. Okay, so that's the background to home reports. And I next want to turn to liability of surveyors for negligent surveys. There's no contract between the surveyor and the purchaser typically, so any claim by a purchaser against a surveyor at common law would rely on the law of negligent mistake, in other words, professional negligence. The standards for professional negligence we'll come to in a second, but the general rule is contained in Headley Byrne against Heller and Partners, the familiar 1964 case, which was expanded in Caparo Industries against Dickman, or some might say restricted by Caparo Industries against Dickman, which introduced a fair, just and reasonable test. And since Caparo, further glosses have appeared in cases like Robinson, which suggests that extensions to negligence will only occur in situations that are clearly analogous to existing liabilities. So it's a more cautious approach the courts are taking than perhaps that stated in Caparo. So if we look at Caparo Industries against Dickman, it's interesting to look at the test and to look at what actually happened. Dickman were a firm of accountants. They had prepared audited accounts, which they are required to do under the Companies Act as auditors, and those accounts are designed to show a true and fair picture of the company for the benefit of the shareholders. There's nothing in the Companies Act that says they're for the benefit of a third party who seeks to acquire a company. So Caparo Industries, it was held, were not entitled to rely on the audited accounts. It was not fair, just, and reasonable so to do. So at some point, it must have occurred to the promoters of home reports within the Scottish government that Caparo might operate in such a way that the surveyor was not liable for a home report where it was prepared for a statutory purpose. It had to exist. Now, the explanatory memo to the Westminster order clearly states that this is required to establish liability for the person who prepares a report on a house towards the purchaser of the property. At common law, we find the law stated in Martin against Bellingham. It was an old Scheme 1 survey, a mortgage valuation that was instructed by purchasers. The acknowledgement of instructions contained an exclusion of liability clause, which would no longer be enforceable because of changes in the law. but it was ineffective because it wasn't communicated to the purchasers before they relied on the survey report. What's important in Martin against Bellingham is the measure of damages. And it was held that the measure of damages was the diminution in value of the property at the time of the purchase. In other words, it was the value of the property with the defect compared with the negligent, no defect valuation. The cost of remedying the defect was held not to be a valid measure of loss, except perhaps as a rough cross-check on the plus-minus defect test. And subsequent authorities follow that test laid out in Martin against Bellinger. Okay, so let's deal then with an example that has been reported of liability of surveyors under the Home Report. In Communal Properties against DHKK Limited, it was said by parties for both pursuer and defender that this was the first reported case to test liability for the single survey within the Home Report. It's worth noting that both the purchasers and the surveyors were limited companies, and it was never in the purview of the Housing Improvement Task Force that anyone other than an individual buyer, a consumer, would rely on the Home Report. But of course, we've got investors and property developers who buy property. The purchasers settled the transaction and proceeded to carry out works on the property, in the course of which they discovered that the roof had certain stability issues. They brought in structural engineers to report, and the engineers reported not only were there structural problems with the roof, but also with the front wall being thrust out by the roof, and the front wall of the building was visibly out of true. Now, purchasers didn't bring in any other surveyors to examine the property in its condition before they carried out works. In fact, they didn't instruct surveyors at all. They raised two claims, one for the cost of the work, which, as we'll see, isn't the test, or which we have seen, isn't the test in Bellingham, and second, a loss of profit style claim. And again, that is not something that's recoverable under the common law, nor is it stated in the statutory liability created by the order. So, in fact, the loss of profits claim wasn't discussed further when the case proceeded to debate. So, under the order, as you'll recall, which I spoke about earlier, to be actionable, it must be demonstrated that the purchaser has obtained a copy of the single survey and suffered material loss with the plus or minus defect test, and that the buyer paid more than with the defect test. The defenders argued that in order to rely on the statutory provision, it was necessary to show that the surveyor hadn't exercised reasonable skill and care. And the parties eventually agreed that the reasonable skill and care test was identical to that at common law. And in order to satisfy the tests, the same requirements as common law would be required, namely Hunter against Hanley tests, 1955 cases, which is familiar to anyone dealing with standards of any profession. Either there has been a departure from a usual standard employed by professionals of that type, or no reasonable professional would have followed the course of action which that professional did follow. So in most cases, it will be the first branch of Hunter that will be relied upon. So in Camino, there was no statement by the pursuers in their pleadings as to how the report was a departure from branch 1 standard in Hunter. The only evidence they produced was a report from a chartered engineer, a different type of professional, prepared for a different purpose. And the defenders focused on that critical departure. The pursuers offered to prove all the requirements in Article 3. One thing's odd about Article 3 is that it's only necessary for the pursuers to show that they had obtained a copy of the survey report contained in the home report, and it's not necessary to aver that it was relied on. Why that is the case is something of a mystery. Neither party referred to Articles 4 and 5 of the order. Article 4 provides that the Civil Jurisdictions and Judgments Act will apply to liability, and in Article 5, jurisdiction ought to be based on the lex situs of the property, which is the subject of the report. That's slightly odd because the case was held in Edinburgh Sheriff Court. The property was in Falkirk, so one would have expected it would be the Sheriff Court in Livingston that would have had jurisdiction over this matter, but that's not something which was pled in the case. Articles 4 and 5, however, do make it clear that it is a separate statutory right, because there would be no requirement to include that because it would already be covered under the Act and common law. So it's very clear that it's not simply a restatement of the Hunter against Hanley test. It is a parallel statutory right. The pursuers sought to get round the difficulty of having only an engineer's report by stating that some cases of negligence were so clear-cut that it was simply unnecessary to prove a departure from any standard, and that this was such a case that the front wall of the property was visibly out of true, and the surveyor ought to have seen that. But the pursuers are a company, and I looked them up in the register, and they are other property professionals is what they show up as. So perhaps if it was so obvious, it's something that should have occurred to them as well. That point was, of course, not pled. But here we're dealing with companies, so it's not a matter of consumer protection, and that was the statement that was said to be essential for there to be a Westminster order. So it applies in all cases because it hasn't been qualified to deal only with surveyors. So that's a little odd. The case ultimately was unsuccessful because there was no relevant surveyor's report stating what the departure from the usual standard was, and the sheriff did not accept pursuers' arguments around it was so obvious. Okay, so surveyors are liable under statute, but the test is identical to that at common law. That seems to be the position. And clearly, if there hasn't been reliance on the report and the surveyor can demonstrate that, then that might open up another argument that hasn't been explored in cases as yet. So now I want to turn to liability of sellers under the Home Report. Okay, if we go back to the statute, there's nothing in the statute, as I mentioned earlier, about liability. If we go back to the two statutory instruments, there's nothing in the forum statutory instrument, nor in the liability statutory instrument imposing liability on sellers. So there is no statutory liability. With a consumer purchaser and a consumer seller, there is normally no warranty. And generally, when buying heritable property, there are no warranties as to the condition of the property. So let's have a look a little at the property questionnaire itself. Some matters in the property questionnaire are routinely checked with the property inquiry certificate. Others, such as council tax band, can again be easily checked. It's always qualified by best of knowledge and belief by sellers. Some matters are not covered by other inquiries normally, such as knowledge of presence of asbestos. But of course, if the purchaser was seriously concerned about asbestos, they might commission their own survey. So the question arises, could a purchaser rely on the Home Report prepared by the seller under normal common law negligence? Would it be fair, just and reasonable so to do? Now, the fair, just and reasonable test has been subject to some criticism as really creating judicial discretion. But my take on it is that it's a consumer-to-consumer transaction. The seller wouldn't be in a position to obtain liability. They're required to produce this for a statutory purpose. So I suspect, applying Caparo, it would not be fair, just and reasonable to extend liability to the property questionnaire. However, purchaser may well feel aggrieved if that were the case, where the answers were inaccurate. Perhaps the best policy to impart to sellers before completing the property questionnaire is, if you don't know, don't tell stories. However, that's not the end of the situation at all. The Scottish Standard clauses in latest version 6, provide in 31.2 that the seller confirms, this is at the time of the offer, that the property questionnaire section is true and correct to the best of the seller's knowledge and belief. It's not an absolute warranty, but if the purchaser can demonstrate that the seller did know that the answer was incorrect, then they would become liable for breach of this contractual warranty. And 31.3, the seller also is obliged to confirm that the information provided by them remains the same as at the date of the offer. So we've got contractual warranties which weren't imposed by statute, weren't thought to be necessary by the Housing Improvement Task Force, but do seem to be thought necessary by the authors of the Scottish Standard clauses. There is also the interaction in the Scottish Standard clauses between the property questionnaire and clause 2 of version 6, the awareness issues question. And here there is also a warranty so far as aware. Is that the same as best of knowledge and belief? Why is there a difference in 2 compared with 31? Some of it duplicates matters in the property questionnaire, but not always in identical terms. For example, in relation to flooding, there are mismatches between what's in the Home Report property questionnaire and what's in clause 2. So for flooding, for example, perhaps you should seek out my presentation on flooding for further information. There's also another presentation that I've done on knotweed, which was found bound up in a previous version of the Scottish Standard clauses as infestation, which I think is wrongly decided. And since then, in the current version 6 of the Standard clauses, there's a separate provision for knotweed, but again, it could amount to a warranty. Moths, there's another presentation I've done on moths, which refers to an English case where moths fell within a representation about other infestations as well. So I hope you found this interesting. And again, to look at the interaction between the property questionnaire, the awareness issues in clause 2, I would have a look at these other presentations that I've prepared. They're also available on this website. If you would like a hard copy of this presentation, then you can find it in the March 26 edition of the Scottish Law Gazette. I hope that's been informative, and thanks for listening to this.